obstacle. It's clearly an obstacle. And it's because it's so clearly an obstacle that we get off on all these sideshows and these arguments about preemption law that are just completely wrong.
So can I ask you for a clarification? Is that what you are relying upon, this conflict, to overcome the presumption that there is no federal preemption absent a clear and manifest expression of it?
Let me say,
I know you've talked a lot about the intent and the minerals in the land, and it has to come out and there has to be impact. And yet, I start from the place where we all start, just, the law school question of preemption is disfavored. And so in order to find federal preemption of a state law, especially implied, that you have to have a clear and manifest expression of the intent. So
that's we disagree on it. And so that's too simple, because there's case after case after case that I cite in the brief where there's no mention of preemption at all. It's a more nuanced approach, and Your Honor's adopted that more nuanced approach in December.
So let me ask you, so you disagree with the statement that we examine the claim of implied preemption from the starting assumption that displacement of state regulation, quote, was not intended absent clear and manifest evidence of a contrary congressional intent?
I think there is clear and contrary evidence here, because what you
Okay, so what is the clear and contrary evidence that you say indicates federal preemption exists?
Because no state ever tried to do this. No state ever tried to ban mining. Every time they tried to do it for 100 years, it was struck down as preempted. That's the background that Congress legislated against.
Did you say the banning of mining?
Yeah.
And your position is banning suction mining is the equivalent of banning mining, period?
If it frustrates the objectives. Take the Brubaker case, Supreme Court of Colorado. All they banned was core drilling. Okay? But core drilling is part of what you have to do to develop a mine. Just like suction dredging is what you have to do here. And they looked at it and said, I'm sorry, you can't do that. Or Lawrence County, or case after case. This would be a different case if they walked in here and said, wait a minute, here's 55,000 state law bans that have been in place for 100 years. Your case last said, and I quote, we have to have reason to discount the possibility that the Congress that enacted the legislation was aware of the background tapestry of state law and content to let that law remain as it was. But there was no background tapestry of state law. This is federal land, and nobody ever thought to go in there and start forbidding things on it. Until Granite Rock was decided in 1987, the general view was it's field preempted.
Counsel, could we look at the logic of your position? As I understand your responses to the Chief Justice, you do not disagree that we begin with the general proposition that preemption is disfavored.
There is a whole spectrum in which that goes. The Crosby case says, in some cases, it's so well settled you don't even mention it. In other cases, food and drug safety, where the states have been in there passing labeling laws, most of these cases are labeling laws, where there's 100 years worth of state regulation, and there's a real powerful preemption. But there's a whole spectrum of preemption here. And this thing falls into the class of cases like foreign affairs, or Granite Rock doesn't have any mention of preemption. Search for the word preemption in Granite Rock. You won't find it, because this is sort of a classically federal area. So the strength of the preemption is a function of this background tapestry of state roles. And if you're going to give respect to a coordinate sovereign, you have to take account of the degree to which these two sovereigns have been active and what their policies are and what they're to accomplish.
Does it matter at all that the sovereign in question, the federal government, has filed a brief disagreeing with your view of the degree of conflict posed with
I don't think
policy?
that what some attorney in the Natural Resources Division thinks about congressional intent is any more than his opinion. I mean, the whole idea that federal agencies are somehow empowered to make decisions in this context. You have agencies that, as a matter of law, in their own manuals say, we can't prohibit it. And we're supposed to believe that these agencies that can't prohibit it were granted by Congress the power to say, oh yeah, but we were granted the power by Congress to authorize the states to prohibit it. It's preposterous. It really is. I mean,
But didn't you say earlier that the federal government's take on a particular method might be relevant to the analysis? I thought that part of your argument earlier, and you correct me if I'm wrong, is the federal government had taken a position with respect to this.
I was just pointing out that the only relevant take we have here, because Mr. Rinehart was on Forest Service land under Forest Service regulations, is the take we put in, which is 228.8, you do it where it's feasible to the extent you can, and then we put in the suction dredge miner who said, okay, give me a plan, and they came back with a plan and said, oh, well, you got to have your California permit. He said, wait a minute, they're not issuing permits, and so the Forest Service struck that from the plan. They were like, as far as the federal government is concerned, you can go ahead whether you have a California permit or not.
Counsel, could I suggest that if you want to reply to Justice Cuellar's question, you let him ask it first?
I'm sorry.
So I simply wanted to understand the extent to which your argument depends on positions that the federal government takes and can change.
I think those are just totally secondary evidence. The primary evidence is that for 100 years, in 1872, in the 1890 Organic Act, all the Forest Service Acts carefully preserved the minerals. 1955, 1970, 1976, we have 100 years of congressional legislation over and over again. That's what matters, not so much what some agency or what some Natural Resource Division lawyer thinks about it. And as I pointed out in the brief responding to that, he's just some kid. I know, we've done cases together. The Solicitor General who signed the brief in Granite Rock, took exactly the opposite position with respect to exactly the same laws that were all in effect at that time. So
well, presumably there were some intervening events, including the decision in Granite Rock.
The law didn't change, congressional intent didn't at all. I mean, the law is what the law is. One lawyer says it means this, another lawyer says it means that, so what? I mean, it's what the law means that matters. And I think the Solicitor General's opinions of what the law was were a whole lot more persuasive than what, this guy's opinions were of the law. I mean, there's whole issues we haven't even covered. There's this whole process whereby states work to induce the federal government to shut down mining, to withdraw mineral lands. Why would we have that at all if Congress thought states could just shut down mining? Why have those federal laws at all? It's fatally inconsistent with a state power to ban mining to have two different statutes, I think it's 30 U.S.C. 1281 and 43 U.S.C. 1712, something, that give these roles to states to try and get the Secretary of Interior to withdraw the land from mineral entry. Why have those? It's manifestly intent that Congress never could possibly have imagined that states would be going out and banning mining. It's just not even, it's not even close. What else did he say that wasn't true? Commercial impracticability. There's been a lot of attack on the Court of Appeals opinion on this point, and in particular about the price of gold fluctuating and so forth and so on. One point that's not in the briefs is that the Garcia case that the law professors rely on was in fact overruled by an unpublished Fourth Circuit decision that I found last week, 442 Fed Epox 745, which adopts a special standard in precious metal cases because of fluctuating prices. So again, there is a whole body of federal law on how to ascertain reasonability that is out there. It comes down to a rule. It comes down to a rule of reason, and I submit that it's just not respectful for courts to. It's not respect to a coordinate sovereign to just say, well, we're going to ban it. I understand that maybe somehow, some way, people think that they need to study something. The record here reflects that the studies were underway years before the ban. The record here reflects the studies were conducted, a set of regulations was produced, it was no harm to fish, no real harm to anything else, a few more, but you can't have stable mineral industries if the state is allowed to ban it and ban it and ban it and ban it. And there comes a point where it becomes unreasonable. And I'm sorry that there's not a more bright line test for unreasonability, but Lawrence County, which the Court of Appeals properly relied on, is dead on point. And it takes what's a very functional approach. It says, look at this thing and see whether it's of a prohibitory character. And that's what a moratorium inherently is, especially a moratorium that sneaks in this substantive provision that we've got to have 100% perfect mitigation, so it's not really a moratorium at all. It's a disguised ban. That's what's going on here. If you look closely at the legislative history, it's all about prohibitory intent. And it's not about just addressing the environmental standards. It's not about, I'm not here because, this would be a different case when Mr. Rinehart was told, well, you can't have a permit because here's a water standard and you violate it. He'd be probably dead in the water if it was a water standard and if he violated it. But it's because the standards approach, the effect-based approach, all of these other statutes, all of the things that are listed in the Federal Service and the Forest Service regulations, it's because these things all were met that they had to come up with these evolving schemes over and over again to just shut these people down no matter what. And that's what this is really about. It's about shut them down no matter what, but let's articulate some environmental concerns and so forth and so on. And I guess what I'd like to say is there's a large body of law, in addition to the law that says the state's purposes aren't really that relevant, there's also law, I think the Perez case, if I remember correctly, which talks about how these assertions of motive they're just not enough. I mean, imagine if the rule were that an environmental effect could justify conflict with federal objectives. So, for example, the state of Arizona recently tried to make things hard for illegal aliens, right? So what if Arizona's position was that, well, we've got too many illegal aliens and it's bad for the environment? I mean, at some level, there's nothing more bad for the environment from a modern perspective than more people. So why can't Arizona clothe it in that and say, we can totally frustrate federal objectives because we're doing it for the environment? Or you can think of a parade of examples, but it's about interference with the federal objectives. And I think once you show interference with the federal objectives, you have made your case. We have carried our burden of proof. Presumptions are funny things. You look in an evidence textbook, you'll see there's different kinds. Some presumptions disappear instantly once evidence is produced. Some presumptions are putting a thumb on the scale. We've never been really clear about what this presumption is, but it's not.
Before your time runs out, since I just heard you say this all depends on, this interferes with federal objectives.
Yeah.
And I have heard you say what those objectives are, but since your case seems to turn on it, would you recite for us succinctly again what the objectives are?
To secure the development of minerals on federal policy, to secure a stable mineral industry, to grant rights to mine that are being frustrated, to establish an overriding policy that notwithstanding inevitable environmental impacts, we will limit our regulation to that which is reasonable and in reasonableness doesn't totally interfere with getting the minerals out.
Okay.
That's all the statutes boil down to that proposition.
Thank you.
Am I?
You have 2 minutes.
Okay. The next thing to go to probably is I think we've covered nearly everything. Just the case, just the history of all the cases. Congress also legislates against the cases, and nobody's been able to distinguish these cases very much at all. He said Lawrence County didn't ban mining, or banned all the mining. No, it didn't. It banned new or amended surface permits. So all the existing surface mining operations could continue. So it was a partial ban, and it banned these permitted operations, and nobody said you couldn't go pan for gold. I mean, in any other context, it's difficult to imagine the state of California coming in and saying, well, you can use a teaspoon, you can use a gold pan, and that's really what the mining law was about. The mining law wasn't about teaspoons and gold pans. It was about getting out significant quantities of minerals. And our clients are here today because that's what they want to do. They want to vindicate the purposes of the federal statute. And so we have the interference with their rights, we have the interference with the objectives, we have the whole line of preemption law that's sort of like land use. What's this line between what's land use and what's an environmental regulation? Water quality standards, that's clear environmental regulation. Saying you can't use the land for this, and he admitted a minute ago, this land is dedicated to mining use. We can't really use it for that.
Mr. Buchal, your time's expired.
Thank you very much.
Thank you.